right, so I have 6:30. I think we probably ought to get this meeting underway. Good evening. Welcome to the first in-person meeting of the Harwich Planning Board in some 15 months. Are we going to be recording this now? Do we have a thumbs up back there?
Yes.
Okay, great.
Red light. This new red light means that we're on.
Ah, thank you. Okay, that's the new fancy tech here. So this is being held obviously in person, broadcast on Channel 18. Members of the public with an interest in any portion or any specific item on the agenda should obviously plan for in-person attendance. And according to Massachusetts law, anyone who intends to record the meeting must first notify the chair, who will then inform other attendees at the start of the meeting. Is there anybody that does intend to record this? Okay. So I would like to open public hearings on the first item A on the agenda for this evening, PB 2021-10, Eastward MBT LLC as applicant seeks to modify a special permit PB 2013-24 under sections 325-51.E of the Code of the Town of Harwich to authorize access to 26 Crocker Rise, Assessor's Parcel ID 116-A2-12, via a proposed shared driveway located on the abutting property at 28 Crocker Rise, Assessor's Parcel ID 116A2-13, requested to continue until July 13th of 2021.
I move that we continue the public hearing for PB 2021-10, Eastward MBT LLC, as applicant to July 13th, 2021, no earlier than 6:30 PM.
Second.
Great, we have a motion and a second. Let me get my pen. I can't think without a pen.
Mr. Chadwick, the second? Is Mr. Chadwick the second?
Mr. Chubb was the second.
Okay.
Roll call vote. Dave Harris?
Aye. You don't need a roll call anymore.
Big pardon?
You don't need a roll call anymore.
We don't have-
We're in public.
Oh, we don't need, okay. So
Oh, yeah.
let's vote. All in favor?
Aye.
All against? Anyone against? Okay, very good. Boy, old habits, new habits die hard, right? Oh my goodness, pardon me. Please help me through this. We will get through this. Now we have public meeting with new business for A&Rs. It looks like we've got some interesting business before the board this evening. First one is PB 2021-12, Christopher Wise as applicant, Andrew Singer Esquire representative, seeks an endorsement of an approval not required plan for 4 buildable lots and 1 unbuildable lot as set forth in MGL Chapter 21, Section 81P. Parcels are identified as Assessor's Parcel IDs 106G73 and 97, no parcel at 0 Halls Path. The parcels are largely in the R-R and a small portion is in the C-H-2 zoning districts and in the W-R overlay and the Pleasant Bay watershed. The plan is entitled Division of Land, prepared for Paul O'Connell trustee, prepared by John McElwee, PLS, dated June 10th, 2021. Mr. Singer, I see you're ready to go.
Good evening, everyone. It's actually a little strange for me sitting at this table, too. I have to sort of get used to this. The first time I've been in a meeting, like sitting at a table, and also the same 15, 16 months. For the record, my name is Andrew Singer, attorney in Dennisport, and with me tonight is Christopher Wise, who is the applicant, prospective purchaser of the land, also Dave McElway, who is the project surveyor, engineer who did the plan. This is, in one ways, a very typical A&R application, and in other ways it's not, because if it was totally typical, you wouldn't be looking at me and listening to me right now. John would be up here. This project obviously has generated a fair amount of interest and passion. What I hope to do with you this evening is go through all the materials that we submitted to you. We did provide a lot of materials to you, and what we would like to do is, as we're discussing this, this is an A&R. So, sorry, I feel like I'm hearing a little bit of feedback on the microphone. This is an A&R. All we're asking you for this evening is looking at this 8 acres, and it's a 5-lot A&R. 4 lots would be single-family homes on conforming lots, and it's up on the screen, that's great. And the 5th lot is unbuildable now, it's the largest lot. It would be, as I noted in the materials, subject to a future 4-lot subdivision. That application, when it comes in, would be a full public hearing, because it'd be creating a new road. Very similar to, as we'll discuss, other activities that the planning board has looked at on Hall's Path in the past. So what we're here tonight, again, is that plan, which is 4 single-family homes that we believe are on conforming lots. What I'd like to go through with you, and this is in the packet that we gave you, it's principally the memorandum that I'd submitted. And if you have questions at any point, please let me know, or you want to discuss any of the materials in more detail. I'd like to briefly review the history of Hall's Path in this part, which is from Pleasant Bay Road to Route 137. I would like to get into the discussion. As you see in our materials, we believe that the evidence strongly supports that this part of Hall's Path is a public way. As you know, an A&R is endorsable by this board, whether it's a public or a private way, provided that there's safe and adequate access. So that will be the final thing that I will discuss. I won't go through all the materials, I just want to mention them to you. So again, if you have questions, please let me know. Hall's Path as a road in this area has existed since the Little Quezon Division in the early 18th century. Approximately 1730 is the earliest materials that we gave you indicating and referencing Hall's Path, and that is a transcription from the original proprietor's book, which is actually held in the town of Harwich. Additionally, what I gave you, again, just demonstrating the existence of the road, not what the road is, but just for now, the existence of the road. An 1831 plan of land for John Hale showing Hall's Path. An 1871 road taking from Route 137 that identifies Hall's Path. A 1938 aerial topographic photograph of the plan, of the area showing Hall's Path. And all of these amazingly show Hall's Path almost in the exact location where it is. It's always been a variable width road. Then there was also, we gave you a 1943 official USGS quad sheet for Harwich showing Hall's Path. And then also gave you 2 land court confirmation cases, plans, one from 1972, one from 1986, showing Hall's Path, listing it as public variable width. We'll discuss that later. And then finally, we gave you excerpts from a court case that discussed, again, the existence of Hall's Path existing back to the Little Quezon Division. And so when you look at all of those, and this becomes important later because I'm looking at the Harwich subdivision rules and regs, what qualifies as an A&R. This is a road that has been around for a long time, and I'll get into that more, but it's definitely been as a road since the early 1800s. The early 1700s. So now we're getting to the question of what is Hall's Path? It's there. What is it? And we believe that the section from Pleasant Bay Road to Route 137 is a public way. It's not a public way in uniform, however. There are different aspects to it. The northeast, what I call the northeast part of Hall's Path, from Pleasant Bay Road to the cul-de-sac, coming southwest, is clearly a town way. It was taken by a town taking. No questions about that. And now there are 3 ways, 4 ways really, that a road can become public. And public's important because when it is a public way, that changes the analysis that you're looking at under the subdivision rules and regulations in the court cases for the determination of endorsing an A&R. So the first part of Hall's Path, the northeast section up toward Pleasant Bay Road, is a public way by town taking. We believe that the evidence that we've submitted, and I'll discuss, that what I call the southwest portion of Hall's Path, from the end of the cul-de-sac out to Route 137, is a public way, both in terms of prescription, estoppel, and also, and we'll discuss a new letter that I learned of this afternoon, also the fact that the road existed before 1846, and there is evidence of dedication. So all of those are methods by which a road becomes public. Now, the evidence that we have submitted to you, and that you all should have in your packets, is again the 1972 and 1986 land court confirmation plans referencing that it is a public way. Also, this board has, and I submitted 2 plans and I have 2 more to give you tonight, repeatedly over the years endorsed A&R plans on Hall's Path when it was a variable width road, anywhere ranging from 10 feet up to 18 and more. Now, these first 2 pieces that I just discussed by themselves would not necessarily demonstrate conclusively that the road is a public way. There are some plans that don't show Hall's Path labeled as a public way. However, there is also a 2000 letter from the Harwich Town Clerk certifying that Hall's Path is a town road. And I also want to distinguish that a town road, a public way, does not necessarily mean that the town is maintaining and upkeeping the road. Clearly, in this case, at least in this middle segment we're talking about, the town has not. But that's not what is required under the zoning, under the subdivision control law. It's looking at a public way, that's a term, or a way that was in existence before the adoption of the subdivision control law in Harwich, which was a date in 1949, or, again, it could be the dedication. So in this case, and if I could, Mr. Chairman, if I could hand out this to you, and I'll go through what this is for you.
Thanks, Andrew.
Thank you.
Could I have one for the file? I just want, thank you.
So, in addition to the town letter from 2000 stating that Hall's Path is a town road, what I just gave you, and there's more than that, but what I just gave you is a 1985 letter from Martin Moran, who was the town engineer at that time, to this board. And it states that, and he mentions dedication, he mentions that based on investigation, he has determined as the town engineer that Hall's Path is a public way. So there's another piece of evidence I wanted to provide to you. If you look at the second plan, or the first plan, the second thing down in that packet I gave you, this is a 2011 plan prepared by the town of Harwich, for the town of Harwich, for easements that the town of Harwich was taking on Route 137. And if you look at that, you will see that the town lists Hall's Path, they called it Hall's Path 1 at that point, coming in from 137, and they label it as approximate town layout. So I also wanted to point that out to you. In addition, the Harwich Assessor's Street Names List database includes Hall's Path as a town road, and I provided you an excerpt from that database. So right now, in addition to the land court plans, the land court confirmation plans and the A&R plans that this board's looked at, you have a letter from the town clerk, a letter from the town engineer, a letter or a document from the town assessor's office, all stating that Hall's Path is a town road / public way. Now, in addition, so that's the words of the town. The actions of the town also consist of the fact that recently, relatively recently, the extreme southwest end of Hall's Path, adjacent to what is now the charter school and was the movie theater before, has been expanded to a full, it looks like, full roadway width dimensions based on what the town of Harwich has done. They also installed drainage in that section of the road, and the town installed sewer stub for future connection when a sewer ultimately comes through. So the town is actually utilizing Hall's Path, expanding Hall's Path, presumably onto adjacent private property and making it bigger. And that's the road, I'm sure you've been out there, that you drive in on when you turn off of Route 137. In addition, on April 15th of this year, the town DPW issued a cease and desist order to the applicant and the owner. And that was because, and that's why we're here tonight, before you, there was a question of process and order, and I'll discuss that. But in the DPW's letter, they also say you need a permission to work on the public way known as Hall's Path, quote unquote. Not only did the DPW in that letter state that Hall's Path is a public way, but if you look on the plan between lots, is it 1 and 2 or 2 and 3? 2 and 3. between lots 2 and 3, a few months ago, the town of Harwich came in and installed an approximately 20-foot wide gate, a bar metal gate blocking access to the road. And the reason why they did that, and we'll discuss that when we talk about safe and adequate, is that people were using the road. And I'm assuming that someone they wanted to impede that or stop that. And so the town came in. If in fact Hall's Path is not a public way, then that gate was installed by the town of Harwich on private property without permission. The fact that the DPW issued the letter saying that Hall's Path is a public way, the fact that the DPW went out there and installed the gate, again, we respectfully submit, is further evidence that Hall's Path in this section, from Pleasant Bay Road to 137, is a public way. To us, the evidence seems very clear that the town has treated, acknowledged, recognized, and documented Hall's Path here as a public way. And so what we're asking for then is we are showing you 4 conforming lots and 1 unbuildable lot at the time on a public way that have conforming frontage, and we submit merit endorsement as an approval not required. This is not an example of what's a so-called ancient way running through the woods. Ancient ways can be public, they can be private. They're just ways that have been around. This road rises to the level of public way based on everything I just said and everything that we've submitted to you for the record. And when you look at the cumulative evidence, we think it's just very, very clear that that's what this road is. Now the question then becomes, all right, we've said it's a public road, and a majority of you will agree with that, or you won't. And we hope you agree. But even if you don't, if you said it was not a public way, then it has to be a private way. It has to be one or the other. A&Rs are granted on private ways as well as public ways all the time. And as I said, and you now have at least 4 copies of at least 4 different plans in your file that you've endorsed over the years, planning boards, showing Hall's Path. And in the packet I just gave you, I wanted to just point out the last 2 because I think they're very important. They were for the same parcel of land on the other side of Hall's Path, just a little way up. In 2004, the owners came in for a 3-lot A&R, and it showed Hall's Path as a very narrow 10-foot way. The planning board approved the 3-lot A&R. In 2005, the next year, the owners came back asking to divide one of the lots into 2 lots. So now you have a total of 4 buildable lots. On that plan, and you can see it right on there, they had expanded the way onto their property so that it was 18 feet in front of their land, which again was just up the street and across. The standard customary tradition in Harwich with A&Rs has been exactly what that demonstrates in that, is that an applicant would come in and they would get an initial A&R from you, they might do some work, they widen the road on their own property, and then they come back and the board has endorsed the next level of the plan. And that's what has happened all up and down the road. And so what the owner had been doing in this case, he had started to do the same thing. He had started to clear land on his property to widen the road so it would match what other owners have done up and down the road over the years. We'll acknowledge, as I'm sure you know if you've read the materials, that the contractor went too far on the southwest side and encroached on land of the Lighthouse Charter School. The owner and the applicant have been working with the school and hope to resolve that. But if you look at everything that's on that plan, the area I'm talking about that was off-site was 1,925 square feet, of which 800 square feet was the road. So it was that small section down off Lot 1. Everything else from Lot 1 all the way up to approximately Lot 4 was where trees were cleared on the owner's land. From there on, the road's already paved. So part of the frontage of this lot, Lot 4's frontage is already paved. Lots 1, 2, 3, and then the unbuildable 5 are gravel. Now, what the owner had been and the applicant had been in the process of doing, which is in custom with what the board had done traditionally, is he was improving the base of the road, for the new 4 lots that were being proposed. And now they've stopped doing that work. The town said stop, they stopped, and that's acknowledged in all of the documents that they did. They would like to finish it. They only needed, I think, to put a base coat down and, and to finish that work. But that is what was being done. And in the Harwich subdivision rules and regs, section 400-9, which talks about A&Rs, it talks about exactly what I just said, which is, I think, why the board has acted that way throughout the years, is that oftentimes the board approves the A&Rs and with the understanding that some work was going to be done. What the court cases say about A&Rs, and court A&R cases are, I have a whole folder of them here. What courts have said about A&Rs is that what a planning board looks at in endorsing is not whether the road's perfect. It's whether the road exists and whether the road can provide access to the lots. And in this case, if you've been out there, we respectfully submit that what's shown on the plan and what's on the ground, absolutely, you can get to the lots. And you can get to the lots in a car. And in fact, more evidence that you can access these lots, again, is the gate that the town put up. The town wouldn't have put up a gate, I presume, public or private, if people weren't using the road. Well, people were using the road. If people are using a road, that means the road exists. And if the road exists and the people could use it and someone felt it needed to be slowed down or stopped, then that is evidence that the road exists. And we respectfully submit that the road is thus not illusory. It's a road. And what the court cases say is if you can get to a property, then it is entitled to and merits an endorsement of the A&R. That's what the applicant believes and is asking you for endorsement. I realize it's a very long discussion for what is normally a very quick review that you do. But we do submit that this plan that's up here now satisfies all of the provisions of section 400-9 of the zoning of the subdivision rules and regs and chapter 41 of Mass General Laws, that when you look at the facts of the case, you look at the history, you look at the use, you look at the town practice, we believe that this is more than merits an endorsement as an A&R. And if you have questions, we'd be happy to answer them, and we appreciate your time. We know that you've been looking at a lot of materials. Thank you very much.
Thanks, Mr. Singer. I'd like to hear from the town planner now, I think, for the town report.
Yeah. Thank you. Suffice it to say, you can get some simple perfunctory approval not required plans to review, and this is not one of them. I'll rely primarily on the staff report I provided to you, but I want to go to the back of that report first, kind of go backwards. There are certain things that should, consideration or discussion points that you should be thinking first and foremost about. What I would think first and foremost about is this a public way? Because if this is a public way, in this case, a town way, your standard for endorsing the A&R is much different than if this was just a way that predated adoption of subdivision control in the town. And I think the applicant has put on fair evidence that would allow you to determine this is a public way, but certainly they haven't provided the evidence that mandates that you find that this is a public way. This is your determination to make, and moreover, the applicant has made a good argument for endorsing the A&R, but certainly it's within your discretion not to do so, and there's nothing that the applicant has put forward that mandates you endorse this A&R. In terms of the public way, it's really the applicant's job. The burden is on them to show that this is a public way. The normal process to lay out a public way after 1846, and I'm too young to remember 1846, is to lay out a way through the town meeting process and the selectmen's process. Admittedly, even by the applicant, that has not happened the entire length of this way. It has only occurred on a portion of it up near Pleasant Bay Road. So other than that, the determination about public way is absolutely fair game for this board. The idea about a public way by prescription or a public way by estoppel, those are certainly recognized under the law, and a public way by prescription is recognized in the general laws. One thing you might want to question is whether or not whether you want to make that determination or whether you're going to rely on some sort of judicial declaration. Generally, when there's something is established by estoppel or prescription, it's generally not done by a board, and it's not generally done by a landowner saying, I have a prescriptive right or an adverse right to XYZ. It generally comes from a court. Do I think that absolutely takes away your discretion here? No, but just understand that that declaration normally is judicially made. I think to the applicant, the importance of this being a public way is the standard for dividing off a public way is much lower, both under the state law and Harwich's own subdivision rules and regulations, than if this were just a way that predated subdivision control, which is February 1949. One thing that is abundantly clear to me, both from my own research and what the applicant has provided, is Hall's Path in this part of town between Pleasant Bay Road and 137 certainly predated subdivision control by even several hundred years. That to me is not at issue. If this were a way that predated subdivision control, what the board basically has to find is the way of sufficient width, grade, and construction to allow vehicular travel and the installation of utilities to service the proposed use. And here, it's 4 lots. Under Harwich's subdivision rules and regulations, the burden becomes even higher, because what the planning board looks at with that type of way is looks at your own Table 1, the subdivision road construction standards. Those lay out minimum layouts beginning at 40 feet wide, minimum paved areas beginning at 20 feet wide, and actually requires that these ways be paved. So again, what you can look at in that case is the way relative to those road construction standards in your subdivision rules and regulations. What the applicant is arguing is this is a public way, so they haven't necessarily addressed the standards to approve a private way under the width, grade, and construction standards. You can do that, but you would have to find that is true. You should also look at it in terms of 4 lots are proposed, not 1 lot, not 2, but 4 in this case. You really have to find that in the case of a private road, you really have to find that both those things are true, that it was a way that predated subdivision control and the road is adequate to serve that proposed use. With that, I'd like to take questions from you. There's a lot to discuss, and as we discussed, Mr. Chair, this is a public meeting. You're not obligated to take public comment, but it's certainly within your discretion to hear from anybody you would like to, including the public on this.
Thank you. Yeah, I think it would be a good idea. We've got a lot of people here. We've had a lot of attention on this matter. I would, however, request that we limit your address to the board to about 5 minutes, if possible, and stick to the matter at hand, which is the determination of the condition as a road, as a public road. So I'd be delighted to take anybody. Do you think this would be, should we have questions for you first?
No, however you want to do it, but since you're going to take public comment, I'm going to take this clipboard.
Terrific.
Put it up on the lectern, if people will please provide their names, get their names down.
And as you approach the podium, we would appreciate just identifying yourself and your address in town. That would be great.
Hello, my name is Sandy McClarty, East Harwich resident. If you didn't get a packet, my wife will pass that out. I would like to start, Mr. Singer mentioned that Hall's Path comes from Pleasant Bay Road from the north side. Maybe I'll wait till everyone's So it was stated by Mr. Singer that Hall's Path comes down from Pleasant Bay. It does not. It's called Hall's Path 1. And this is important because it stops at, there's a kind of a roundabout cul-de-sac, and then it narrows down to a 10-foot way that's restricted. Only one car can get through there, and then it widens back up. To the right is Walden Woods, and then it continues on to dirt. And then coming from the south side, again, you have this road, and I don't dispute that it's a public way. Comes down to a bottleneck, if you will, between the school and the Smith property. And I believe it's at least 15 feet. There's a bottleneck on the south side. And so in order to get the adequate access as determined by the town rules, you need 20 feet. They would have to get permission from the school, as I understand it, or from the owners of that bottleneck where Hall's Path 1 meets Hall's Path. So I believe that is a problem going forward for this. In the packet, which I hope some, if not all, got a chance to read it, I'm citing the case, the Ball case versus Leverett, 2003. And January Road, the road in question, is clearly a public road. There's been a lot of talk about, is it a public road? Isn't it a public road? Very clearly, the January Road case is or was a public road. And so I think we have to dive a little bit deeper. And so I will just read, I won't read the whole thing, but this is the determinations by the court. As was discussed when the owner and proposed purchaser and their legal representatives recently met on site and walked the section of Hall's Path along with representatives of the town building and planning department. I'm sorry. This is the section from John. We conclude that January Road, as it existed at trial, did not provide adequate access, emergency vehicular access to Lot 1, and hence that access was in the illusory category. That's key. It goes on. Admittedly, January Road is more than a paper road or paper street, but it provides no practical means of access for emergency vehicles to Lot 1. The uncontradicted evidence at trial establishes that January Road does not provide access as contemplated by Section 81M, and that its adequacies place it beyond the deficiencies of the way at issue in Sturdy, Note 3, and beyond the, quote, could be better but manageable category referred to in Gates, Note 4. Now, that same Gates case in 2000 was the one cited by Mr. Eidman, and I'd just like to read one portion of that. In the Gates, it stated, unless the public way is illusory. And then Mr. Eidman goes on, he says, i.e., and this is his opinion, it is either physically impassable, doesn't allow physical access to and within a building lot, or simply doesn't exist on the ground, which a division of a public way warrants. So there's clearly a difference of opinion there. In this case, it's clearly stated that it's there in person. January Road, you can walk on it. And if you go on to read the letter presented to you, they describe the road. It's 1,000 feet long. It's 200 years old. But you could four-wheel drive on it. But if you had a two-wheel drive, and that was the distinction in the January Road case, is that the two-wheel drive vehicles could get stuck. And finally, I'll just close. When you look at, I've been reading, I'm not an expert at this, but I've been reading the planning, the A&R handbook as presented by the Commonwealth of Massachusetts. And on page 42, it says determining A&R endorsement. I encourage everyone to read it. It's about 2 or 3 pages. It's not hard. And there's A, B, and C. The first one, A, well, let's back up. Do the proposed lots shown on the plan front on one of the following types of ways? A public way or a way which the municipal clerk certifies is, quote, maintained and used as a public way. So it is important that it is maintained, contrary to what has been stated before. I won't read B. And then C, as I don't think it applies. C, a way in existence when subdivision control law took effect in the municipality, which in the opinion of the planning board is suitable for the proposed use of the lots. And then they cite cases which deal with the adequacy. So the question is, does it fall into the could be better but acceptable, or is it illusory? And that term illusory is not just, a paper road. It can be on the ground, but if it's not safe for fire, and again, I believe there's 2 issues. the case I'm making right now, but also the fact that you have the bottleneck that is owned not by the party in question here. And I think that's it. Did I miss anything? I'm done. Oh, one last thought, and I see my note. A very reliable source to me has told me that Mr. Eidman worked for the Singer law firm in the past, and while I wouldn't say that his opinion is biased. I wouldn't say that, but I feel if it is true, it should be disclosed, and I would ask through the chair, did you formally work? I would ask Mr. Eidman, did you formally work for the Singer law firm? Thank you. That's all I have.
Thank you. Done.
I'm Don Howell, on the Board of Selectmen, and more to the point, I'm your new liaison. I want to introduce myself in that way. I normally would be at this point telling you that the Selectman liaison is a conduit for you to say, if you got a problem, I'll take it back to the Board of Selectmen and vice versa. But I feel compelled to address what hasn't been said tonight. The Board of Selectmen has, under the charter, powers of investigation. The last time I saw them exercise that power was when I was in office in the early 2000s. It's been 15 years. The Board of Selectmen voted a couple of months ago to launch an investigation into how this road got to where it is at this point. I know from my own perspective, I've been down that road basically in December. It was barely passable, and I have an SUV. In the course of doing what was done there, which was done without any town involvement, there were at least a half a dozen monuments that used to delineate where the edges of the property were. They're gone. They were removed along with the trees from the charter school when this endeavor began. And I got to make the point that it's not about any particular person hiring somebody, because we had no idea at that point who it is who was the actual owner or applicant. But we thought that this was egregious enough where we've actually contacted our legal counsel to assert our rights in this as a Board of Selectmen. Now, as to the gates, I think it's rich to characterize it as us acknowledging that that's a passable road, because it wasn't passable until they did what they did. It was put in there to stop any further excavation of this property pending somebody coming in front of the planning board to actually get some ruling about whether it was or wasn't sufficient for frontage. It has no drainage. It did not have gravel until just fairly recently. You will not be able to figure out where the properties start and stop, because the monuments that used to delineate that are gone. And from our perspective, the selectmen consider this to be an egregious act, and we are not pursuing with our own legal counsel any avenues that are available to us. Thank you.
Thank you, Mr. Howell. Anybody else wish to address the board? Please.
Thank you. I'm Clara McClarty. I live on Pleasant Bay Road, East Harwich. One thing I wanted to add to what Don said is that Attorney Singer said the gate being there proves that people were driving on it, because the gate's there to stop people driving on it, so people were driving on it. Of course, that was after the illegal changes. Before the changes, it was not possible for anyone to drive on it without four-wheel drive. And we also have attached in the things that we gave to you testimony that fire department considered it inaccessible, as well as from the DPW that they did not maintain it in any way. I live on the Pleasant Bay end and maintain a Food Forest Initiative garden at the school, and it would have been very convenient for me to pass it, and I tried once, and I had to back out in our minivan. It was not possible for any regular vehicles to pass through before the illegal work was done, and I don't see how, if you make the consideration based on after the illegal work was done, that would be to reward illegal behavior. I also wanted to just say that there's been a lot of talk about the tradition of what another builder did or another subdevelopment. The tradition in Harwich is to approve this. The tradition in Harwich is to allow this. It has been the tradition on Cape Cod since the 1950s to have the primary source of income from the development of land, but we're reaching a point where we need to reconsider that tradition, if it is a tradition, and we need to use all the legal means to oppose and prevent these type of things. Even if there was a tradition of leniency or tradition of seeing people who take unknown owners' land and then put it into the tax base, and traditionally we saw that as a positive. Now, considering that we're up against climate change and housing crisis and the sixth mass extinction and all of these things, water quality, the costs of sewering, we need to change those traditions if they are merely traditions, and instead use the full extent of the law to protect Harwich for the citizens who live here and not for the millionaires who will buy these big, expensive homes. Thank you.
Thank you very much. Anybody else wish to address the board from the public?
Good evening. I'm Eleanor Smith. I live at 1360 Halls Path. Ours was the first house to be built on Halls Path, so I'm very familiar that it is indeed a public way. And the letter that Attorney Singer read from Marty Moran, he wrote that on our behalf. I work in the surveying industry. I'm not against development. I just would like to describe Hall's Path when we first moved into our home. It was a horse trail. To access our lot, which had previously belonged to Cape and Vineyard Electric Company, the electric company had to put a different road in over other property that they owned, which has since grown in, but I can show you where it was. If you look at the trees, you can see the original trees, you can see shorter trees, and again, taller trees, and that's where that road went. Has nothing to do with this case probably, but we could not have accessed our lot from Hall's Path. It was maybe 4 feet wide. As we built our home, we had to clear Hall's Path as it was shown on the land court plan to make it wide enough for us to access. And we were allowed to widen it to 8 feet wide and clear 2 feet on each side of that. It was established at that time that Hall's Path was considered to be 8 feet wide. Our deed describes Hall's Path as being 10 feet wide. From our lot going north, after we had constructed our home, there had been the normal amount of trucks and so forth in there, and the original location of Hall's Path had been moved a little bit. We have since put it back to where it was. And after we had been there a few years, various vehicles tried to come through. Eventually somebody did manage to cut a tree down, and there has been vehicular traffic through there off and on. I would say there have been at least a dozen cars stuck. There was like a washboard effect, and they would go up and the carriage of the car would be stuck on the humps. There were 2 huge puddles that various cars got stuck in. If you go down there, you can see a pile of timber that we have left for people who got stuck so they could get out. More than once, my husband has gone down with a shovel to dig people out, and there have been big wreckers come in to pull people out. It was not safe until this was done, the clearing recently. That's all I have to say.
Thank you, Ms. Smith. Anybody else wish to address the board?
Good evening. My name is Sarah Toronto Flores. I'm an attorney with Nutter, McLennan, and Fish. I represent the Cape Cod Lighthouse Charter School. We submitted a letter earlier today to the board. My school board only found out last week about the application, so I apologize for the letter today. In it, you'll see that we've requested that the board delay its decision until its next meeting. I thought you met next week. I realized Mr. Eidman told me this evening that it would be a month from now. It will require the applicant's waiver of the 21-day period. But we're asking for that because the board has not met to discuss this A&R application. So I can't report to you its position on the A&R. The school board has previously met to discuss the cutting that occurred, and Mr. Singer alluded to it in his initial presentation. When the road improvements were made by the owner of the property that's being sought to be divided here tonight, cutting went beyond the historic layout of Hall's Path as it existed on the ground for many years. It's visible in historical aerial photographs, and the pavement of the entrance to the movie theater eventually narrowed all the way to 8 feet wide, and vegetation grew up to that border, and it existed like that for as far as the aerial images go back on Google Earth into the 80s. And that pinch point of 8 feet is what was lost with the recent cutting. So now that cutting has widened that what had been a pinch point for quite some time. And that has been the subject of discussions with the property owner who was very cooperative, immediately owned up to what they did, and did approach the school immediately and seek to rectify it. A proposal that was made was to plant that back. And the school board has on its agenda on June 28th to review that proposal. Now it will also be reviewing this A&R plan, but at this juncture, I don't have any ability to report to you what the school's position would be on the A&R itself. Just wanted you to know that one of the proposals would involve the replanting of that back to its prior form, which would be an 8-foot width at that northwest corner of the school property, right as it then passes the school property onto the property sought to be divided here. In my letter to the board, what we did want to make clear, though, is that it is the school's position that it's a private way. I'm not sure, there's been a lot of talk about that. I think that Mr. Singer, Mr. Eidman, and I are all on the same page with regard to what that distinction means. If it's private, I've put the two different standards in footnote 1 on the first page of my letter, but if it's private, and it existed prior to the adoption of the subdivision control law in Harwich, then you do have to find that it is of sufficient width, grade, and construction to allow for that vehicular traffic and the placement of utilities. If it's public, though, you still have to find that it's safe and adequate. So there's different standards that you have to find here, depending on whether you think that it's private or public. And I think Andrew's put forth his reasoning for why it's public, and I've put forth my reasoning for why it's private. I agree with Mr. Eidman, particularly where there's been no layout, town layout of this portion of Hall's Path. There's been no recorded evidence of any dedication prior to 1846, and remember that dedication not only needs to be made by the property owner, but there needs to be formal acceptance of that dedication by the town, and there's no evidence of that. So the remaining way for this road to be considered public is under prescription, and as Mr. Eidman alluded, that's usually adjudicated by a court of competent jurisdiction. Here and I also put the standard for what prescriptive, a public road created by prescription would entail on the second page of my letter with the attendant case law. It's a tricky, factual determination. It's very, very factual and case by case specific. But in the end, it doesn't preclude this board's approval. Either way, whether it's public or private, it just means that different standards are applied. And to that point, I guess, whether the road as it passes through the school property and approaches that northwest corner is reduced to 8 feet will be relevant to your inquiry. And for that reason, we are requesting, and I understand that the applicant must agree with that, but that the board just have a continuance to its next meeting so I can report both the board's decision with regard to the planning proposal currently under consideration and proffered by the landowner who did the cutting, as well as the board's position on this A&R application. So with that, I'm happy to take any questions. That's all I have for tonight. Thank you so much.
Thank you. Anybody else wish to address the board this evening?
Yeah, Bud Escher. I live on Hall's Path, 1378, right across from the proposed drive to Lot 5. In the 15 years, well, 16 years this year that I've been out there, I can't count how many vehicles I've pulled out of that section of the woods. It's only been 10 to 12 feet maximum. I actually had to take a piece of equipment out there and tow a furniture moving van out of there that took the whole front top corner off of the vehicle. The gentleman that owns RPM Carpet, when some of the sewer was being done, I guess about a year and a half ago, got his $160,000 Mercedes stuck in that hole. Asked me to take it out with a chain. I said, no, thank you, sir. Call somebody that's got insurance for that. Nonetheless, without four-wheel drive, and I drive a Jeep that's got 38-inch tires and 6-inch lift in it, I can pass through there, no question. Up until this clearing was done and the road was widened and then kind of regraded, I guess. There's no drainage out there. To my knowledge, I don't see anything. You couldn't get through there unless you had four-wheel drive. The reason the gate was put up, to my knowledge, was because of the grinding of Route 137. The school board said to the parents, use Hall's Path 1 to come through. Now, without talking to any of the abutters or anybody on Hall's Path, that morning I had 150 plus cars come across in front of my house. Same thing following day. And at that point, the school was asked not to bring any more traffic through there. And I believe the paving was done at that point, and that's why they stopped coming through. I was called and told that there was going to be a gate put up, and I watched them put it up. The only reason the gate was put up is because way too many cars were coming through, and to my knowledge, the school was concerned about the benefit of the children. That's the only reason the gate's there that I know of. But also to stop any future destruction of trees and property out there, whether it's theirs or somebody else's. So I guess that's all I have to say. I'm not a big fan how it was done. I'm not a big fan of whoever was running the excavator that day, moving my trailer, dropping trees across a kayak that was out there. But it's done. I can't change it. Just like to say that I think a reconsideration or even a postponement till the next meeting so the school board can get a hold of this would be a great idea. Thank you.
Thank you, sir. Anybody else wish to address the board? Mr. Howell?
Yeah, since Mr. Escher just brought this up, I have to be very clear. It was not the school that put the gate up.
Right.
The Board of Selectmen instructed the DPW to put the gates up in order to prohibit more construction equipment going through.
Mr. Chair, could I just orient the board? So Ms. Toronto Flores was talking about this area here. Here is some pavement on the school's property. And Andrew, correct me if I'm wrong. Does this dotted line basically represent the area that was cleared off of Mr. O'Connell's property, the dotted line there?
That dotted line, the trapezoid that creates is 800 square feet, and that was cleared. There is an additional 1,100 square feet that is not shown on this plan, but it's off. I do have a plan that shows it. The total is 1,925 square feet. And again, all acknowledgements that that was a mistake and shouldn't have been done that way. But to answer your specific question, the dotted area on that plan is 800 square feet.
Great, thank you. So does the board have any questions then?
Mr. Singer, so the dotted line is private, another person's private property?
That is correct. That is the school property. Absolutely. If you'll bear with me.
Bill, the heavy line is the line that represents the land in Mr. O'Connell's purported ownership. So everything outside that is somebody else's property, and specifically this, as I understand it, belongs to the school.
Yes, and so if you follow, I don't have a clicker with me, but yeah, so that area inside is the 800 square feet I mentioned. If you look at, you see how the road doglet kind of stares, right? So if you took a line, yeah, so if you could just go up to the property line. If you just went from where that comes out up to the property line, that's approximately, not exact for Sarah, but it's approximately where the tree line was, and that area was the part that was cleared, correct. And that, Mr. Stoltz, you asked the question. That is school property. That is what Sarah referred to, that we, that the parties have been talking to respond to that. Yeah. And-
Looks like we have one more member
Please.
from the public. Please state your name and address, please.
Sure. I'm Peter Banziger. I live on Hall's Path, and I'm the property across from proposed Lot 4. I'm sorry?
Which proposed lot?
Lot 4 that's on here.
Thank you.
I live across the street. Right, exactly. So I have a question. If the board approves this A&R, are these the specific and exact lot dimensions, et cetera? That's question one. Question two is, it appears that there's a space between lots 3 and 4. And logically, one might conclude that there's a reason for that. What's the distance, or what's the dimension there? And is that enough to sustain a road or whatever to access Lot 5? Because I think the application also referred to an additional 4 lots, or that Lot 5 would be subdivided subsequently into 4 additional building lots. And is that how access would be granted to that property?
Thank you for your question. Mr. Eidman, can you enlighten us?
Yes, so those are for lots 1, 2, 3, 4, and 5. That's how the lots would look if the A&R plan was endorsed, it was recorded, and there was
And
building.
that's locked down.
That's locked down unless there's another A&R plan. Or
Okay.
another subdivision plan. But Lot 5, I don't think the applicant makes any bones about the fact that their intent is to not just divide that, but subdivide it.
Right.
Which means that the applicant would have to go through the full subdivision process to lay a road out over what you see as that kind of funnel-shaped piece.
And so what is that process?
A full subdivision process is a public hearing, and that roadway would have to meet all the requirements for a road under the town subdivision control law. It would have to be, in this case, a 40-foot wide road layout, 20 feet of paving, and the requisite drainage requirements, unless waivers were sought. So sometimes an applicant will seek certain waivers to keep a rural character to a roadway if there's, let's say under 5 lots or so.
Yeah. So do we know that distance between lots 3 and 4?
If I could read the plan from here, I would. I can find out that distance for you.
If I could, Mr. McKelway's here.
Yes,
He
please.
prepared the plan.
The narrow part there is 50 feet wide, long for a 50-foot
So,
wide.
For the record, the narrower, on the microphone, the narrower part, the longer part in the middle is 50 feet wide.
Thank you very much.
So reasonably, if you approve this A&R, there's going to be another one for that lot, right? Yeah.
That would be, as we noted in our application, Mr. Chairman, to Mr. Danziger, that would have to be a subdivision
Separate
application
subdivision,
for a
right.
public hearing as opposed to an A&R process. You could not do A&R lots on what is Lot 5. It would have to be a public hearing process.
Okay, and how does, I believe I saw something in the application with respect to sewerage and common septic for these 4 lots? And if you get to 5, does that common sewerage still apply? Or,
Mr. Redmond?
Yeah, through you, Mr. Chair. The Board of Health regulations provide that for any development over 5 lots.
over
And-
5 or 5 and over?
5 and over, I'm sorry,
Okay,
would require a common septic system with nitrogen-reducing technologies, if it's not otherwise hooked up to the municipal sewer system.
so if these lots are buildable, and I understand this may be getting a little bit beyond what this A&R discussion is about, what's the sewage plan for these 4 lots? Or is that out of your scope for what you're trying to decide?
Yeah. Unfortunately, that's not something the board can get into. The A&R process is an exception to the subdivision process. During the subdivision process, the Board of Health can absolutely weigh in on the means of sewerage. It's simply not something that the board is allowed to get into under the state law or its subdivision rules and regulations for these types of A&R plans.
Okay, thank you.
Thank you for the questions. Anybody else from the public who'd like to address the board? This is your time. Because I think the board probably has some questions both for Mr. Singer and for Mr. Eidman.
Could I respond?
Yes,
Just
please.
if there- I just wanted to wait to
Mr.
make sure there's nobody else. Just a couple points, and then we welcome your questions. Ask you to look at, in the Harwich subdivision rules and regulations, and this is in response to one of the comments I heard, it defines several things that are not subdivisions, ergo, they're A&Rs. One is a lot that's divided with frontage on a public way, or a way which the town certifies is maintained and used as a public way, or a way shown on a plan therefore approved in accordance with subdivision control law, or a way in existence when the subdivision control law became effective, having suitable width and all that. So, in this case, we believe it's a public way, but in any event, it's clearly a way that existed on February, or whatever the date was in 1949 that John mentioned. So we believe that this way absolutely, falls within the bylaw. And again, I won't go through all the cases, but in response to one of the questions, the court cases do note that, it's not perfect access, it's access, and you can get there. And this is a variable width road. And I think, with all due respect to one of the comments, tradition and practice and fairness is very important. And it's different in every case that you look at. Obviously, that's why we're here tonight. However, when you look at how Hall's Path has grown over the years, clearly, and you've seen it in all different parts, and it's a variable width road, and that has happened consistently and legally over the years. What the applicant's requesting from you tonight is an endorsement for the same thing, and that the road, in providing access to these lots, whether you came from Pleasant Bay Road or 137, will have safe and adequate and suitable access to get to it. I acknowledge that we'll be talking with the school about, that piece, but when you look at what the board has approved with 8 and 10 foot widths over the years for more than 4 lots, 3 lot A&Rs, 4 lot A&Rs, there's even a 2 or 3 lot subdivision a little bit further up the street that was on a narrow section. This clearly, we believe, meets the ability to approve it, whether as a public way or as a private way, although we believe the evidence is pretty overwhelming on the public question. Thank you, and welcome any questions.
Very good. Joe?
Andrew, just a quick question on lot number 5. There's 198,000 square feet. Maybe people in the audience can't see that.
Okay.
We're fortunate enough to have something in front of us. What is the long-term plan in terms of that? Is it your client's intention to subdivide that?
Yes, 4 lots by subdivision. So the intent now, and obviously maybe it'll never be done, but the intent, as we stated right up front in our application, is that Lot 5 would at some point in the future come back for a public hearing process under the subdivision control law to create a roadway in from Hall's Path and 4 single-family residential lots.
4.
4. So there'll be a total at the end of the day, there'll be 8 lots. What we're asking for today is 4 buildable lots, 4 houses.
Trying to figure
But there could be 4 more. And again, to the comment in the staff report, we'd have to be, whoever that we is, might not be me, would have to be discussing that with the Board of Health.
Thank you.
Mr. Chairman, thank you. I'm not sure if this is a question for Mr. Eidman, but I'll address it to you, and if not. I'm trying to simplify this in my head as much as possible. It sounds like the decision we have to make is it a town road? And does the application that we've received preclude the 1949 subdivision control law, therefore making this an AR versus having to go before a planning board with a different process for subdivision, as you just explained? Are those the two?
Well, no, I think those are in
Is
the,
your question whether or not Hall's Path is a public road?
My question is that what we have to decide here or understand so that we can then make whatever decision each of us wants to make in terms of the A&R? And I say that, and I'm going to add this in, because there are a lot of issues that have been discussed about cutting, whether intentional or in error, and all those things. But I don't see how those are relevant to the facts that we need in order to make an appropriate decision. And so I guess I ask that as a question. Are those are those things that the board should consider in making a decision? And I add to the fact that it's been stated by the Board of Selectmen that they are investigating all those other peripheral, if you will, issues, not peripheral to people, but to our core decision-making process. I hope my question, albeit long, makes sense.
yeah, no, unfortunately, this does have some complexity to it, but I'll try to simplify it as well.
Please.
What you've mentioned is really in the alternative. What you have to first determine, is this a public way or not? Because if this is a public way, the law is pretty clear. Unless it's illusory, unless the way is illusory, it's paper and doesn't exist. If it's passable, basically it warrants an endorsement. Now, the case that Mr. McClarty mentioned, you do have to, all these A&R cases are very fact-specific. This specific case, I think they mentioned that there was no defined roadbed. It was leaf litter, it was peat. It almost seemed, reading the case, that the road itself wasn't defined. That's clearly not is what's going out on, Hall's Path now. The other very difficult issue that's going on is it happened. It's cleared. It's cleared out to 22 feet, and it's largely gravel. How that happened is the subject of other discussions, but those are the conditions. The law is also quite clear that when you're deciding and looking at an A&R, you take the existing conditions as they are. So that's the condition you're looking in. I know that's a difficult pill to swallow because there's some discussion about, well, there are some allegations that it was done improperly, but it is what it is at this point. That's the existing condition.
And if I may follow up, and how it got there is immaterial to this board in our decision-making process.
In one sense, this is a very limited determination. Now, I mentioned this is in the alternative because if you don't think this is a public way, then you get into a much more, I think, complex discussion that invokes much more of your discretion about whether there are sufficient width, grade, and construction to allow access to the proposed lots here. So I don't know how you want to handle it. I don't know if you want to have kind of broken down discussions first about whether you think it's a public way. Ultimately, the motion at the end of the day is simply whether this is a subdivision and whether to endorse the plan is not requiring subdivision approval. But there are things you have to discuss to get there.
Thank you.
Through you, Mr. Chair, to Mr. Eidman. So essentially, any bad acts are going to be dealt with in a private matter. So if it was cutting down trees on our property, if it was wrongly opening a roadway without a roadway permit, or cutting down the school's trees, those are all gonna be determined outside the course of the planning board.
I know that's a
So-
difficult thing to hear, but absolutely, an endorsement
trying
is
to-
pretty limited.
I just want to make it clear that, so that everyone understands what we're looking at. And what you said is that we have to take it as it is on the date of our hearing. So how it got there will be
Somebody else.
somebody else's determination on damages and how to rectify it. But as of us sitting here right now, we're looking at a 22-foot roadway that's cleared with gravel on it, as opposed to an impassable 8-foot roadway that you would have needed a four-wheeler and a lift kit to get through.
And it's not entirely 22 feet. As I understand it, what that plan shows is it's largely 22 feet wide, and there are parts that it narrows in towards that funnel of the unbuildable lot. And then some of it is actually paved, I think, out to a width of between 14 and 16 feet. You'd have to check with the applicant on that. And then, of course, it's paved on the southerly property.
And then just one follow-up, has the fire department and the police department, and perhaps Public Works, looked at it as it currently exists, or provided comments as it currently exists, like they would on another situation?
They have not to me, but, I understand Mr. McClarty has gotten their comments and provided them to you. Maybe it's a lapse in the regulations, but normally in A&Rs, we don't go and solicit comments.
Understood.
It's done absolutely in the subdivision process. So no, I have not gotten those comments.
Understood.
Dave, you had a question?
Yeah, I just want to be perfectly clear that if Hall's Path was a public way originally, years ago, and it was not maintained to provide an adequate passable way for traffic, except perhaps for special vehicles such as four-wheel drive Jeeps and so on, would it then lose its status as a public way had this application been submitted when the road was in that condition?
Interestingly, on the basis that the applicant is arguing, perhaps, because if they're arguing public way by prescription, there's not a layout here, then you can essentially, if you don't continuously use that way, the public using that way, not just select members along the road, then you can essentially lose those prescriptive rights you've gained. So again, it's really important to understand, why this isn't or maybe is a public way. It's not because there's a layout. It's because the argument is it's been used continuously without permission by the public for 20 years continuously, or there's another argument we haven't gotten into that much, but it's all called a public way by estoppel, where basically it prevents the town from saying it's not a public way based on the town's own conduct and behavior. It's a much more exotic argument. I'll go back to what I said from the beginning, that there's been evidence provided that I think would allow you to call it a public way, but there's been nothing said that mandates that you treat this as a public way.
I just wanted to.
Helped a bit.
I just wanted to point out that it seems to me as though the matter of precedent here is of some relevance. It may not have direct bearing on our decision-making on whether or not this is a public way, but the town, through Mr. Howell as a liaison with the selectmen, has said that they want to go, they're going to pursue this as a matter of course so that this is not repeated. So we should bear in mind that we don't want to essentially rubber stamp a process that the town wants to put to an end to. In other words, you can't create the circumstances that you want to have and then just say, oh, that just happened by accident. So I think that's one of the kind of hot potatoes that we're dealing with. That's number one, the way I look at it. So we've got to deal with that reality, that the town is willing to go to the mat, as Mr. Howell said. Number two, it's like a logic puzzle here for me. I hear contradictory evidence about the legal nature of a public way versus the physical reality, the empirical reality of traveling and accessing and servicing properties that are going to require potentially, fire hazard. And if we're talking about vehicles bottoming out and requiring, this is an issue for us. So I think that, this is part of our deliberations tonight. And can I just ask, the attorney that representing the school suggested or requested a delay that is a 21-day. What does our calendar look like if we were to delay this evening? Our next meeting is
July 13th.
July 13th. So
You have two matters, but of course you can fit this onto the agenda. And you can't do that unless the applicant basically waives the 21-day period to act.
right, because I think that we haven't even gotten into like a lot of the substance here about some of these dilemmas from our own point of view, and I think we need to have that discussion. I just wanted to lay those cards out on the table because I think some of them are implicit, some of them are explicit, and they need to be addressed.
Mr. Chairman?
Through you, I just want to clarify with Mr. Idman, because if the applicant doesn't agree to the extension, it would, and we fail to act within the 21 days, then the town clerk endorses it.
Automatically,
Automatically,
right.
Constructive
correct.
endorsement.
Right.
I just want to point that out for those watching so they understand the process, and that's.
Thank you for the clarification. Bill.
Mr. Chairman, from what I understand, what I know about Hall's Path, from 1962 to today, the section we're talking about right now was not passable by a motor vehicle of any quality. And from Pleasant Bay Road all the way through, when I was first married out there, you had to walk down that road. You could not take a motor vehicle down unless it was a motorcycle,
Right.
and then later on an ATV. So, and a lot of that property, that path, was owned by homeowners on either side of it. So it probably was a private way in sections and maybe a public way in other sections, and we don't know exactly what is really going on, and I think it needs to be investigated before we can determine and doing a subdivision. And besides that, an 8-foot wide road is not acceptable by the town.
So you're saying that are you saying implicitly you do not want to endorse this?
I don't want to endorse it, no.
Thank you.
I just have a question for Mr. Stoltz. You're saying that at least in some areas, the property owner came out to the middle of the road
I actually own both sides.
in some instances.
Yeah, yeah. And if they didn't, when they did, when Hall's Path 1 went in, Mr. Marsh developed that by using his own land, not by using just Hall's Path. And he continued that on. And we, at one time, made him I think it was Bill that we put that little 10-foot paved way in so that two of those subdivisions were connected on the back sides for emergency vehicles. And I know for a fact that the town never maintained that road, or that section of that road, because I used to plow snow for the town, and that was on my route, and I was not allowed to plow it, because it couldn't be plowed.
Because it wasn't,
I couldn't get
a
my
road,
truck,
basically.
I couldn't get my truck down there.
Arthur,
Mr. Chairman?
did you have a question, Arthur? No, okay.
Could
Mr. Singh?
I just clarify, if I could, a couple things, 'cause I realize complex question. A public way does not mean that it's necessarily not privately owned, because the towns, as you know, often take easements. So there could be private owners, whether it's public way, so very often you have, but it's the public easement. That's what makes the public way. Also, what you referred to, Mr. Stoltz, with what Mr. Marsh did up the way, took his own land, you said, and made the road wider. Well, if you look at the 2005 plan from the Spencers that I gave you, they took their own land and made the road wider. If you look at other lots, that's what they did. If you look at what Mr. O'Connell, the current owner, did, and look at the dots on this plan, it's exactly what he did. He
Except
took
where
his own land and he was so he didn't make the road that's there is better, absolutely. But he used his own land to do it. He did it the way that everyone else has done it. If you look at the 2004 plan from the Spencers, the board initially approved a 3-lot A&R when it was an 8 to 10 foot wide road for 3 houses. Then a year later, they widened it to 18 feet, and not you exactly, but the board granted, the 4th lot.
Right, using their own property.
Using their own property. That's what you've got here. You can see it on the plan. Mr. McElway has shown you where those lines were and are.
But the difference is, coming from 137, your client has widened that road on somebody else's property.
Okay, then come from Pleasant Bay Road.
Well,
You can do that because again, when you come down, it's paved, as I said, through, lot 4, and then access comes down. Well, if that then, to your point, the same way that the Spencer property, the 05 property, and the 2 gentlemen who spoke, Mr. Escher and, I'm sorry, I can't remember the other gentleman's name, but, you come down, those are the same, it's the same thing that the board's approved repeatedly. So you come from Pleasant Bay Road if you're not coming from 137.
But
That's all I'm saying.
Yeah, and that's a whole nother investigation, because you don't know about some of that property, who owns it and who does not own it.
Well, no, actually, we do not believe there's any title question, and letters have been submitted from an attorney who's examined title and writing title insurance, so we don't, and again, that's not something you look at, I appreciate that, but we don't believe there's any issue there.
Even where the little 10-foot wide section of paved road is?
Going to the northeast, correct, that's our understanding, correct. Granted, where the school is, that's a
Understand.
separate issue.
So we have to that would have to be found out.
No, it's been submitted to you, I mean, there's a letter in your file.
Yeah, we put a title letter. I did request a title letter to support the plans that we have. And so we can look at title in terms of site control, but we basically can't do a title search.
Mr. McClarty, I saw your hand up.
Thank you. Yesterday, I spoke for 2.5 hours with Thaddeus Eldridge of Chatham. He's the land surveyor that you find in the packet that was representing the Eldridge Public Library. And I'm not smart enough to know all these details, so I didn't come up with this. But in that conversation, he was very explicit that the 10-foot wide road on the north side between Hall's Path 1 and Hall's Path is a problem. You need 20 feet, and you don't have it. So even if you could drive a Lamborghini down Hall's Path, you still got to deal with this problem of access from the north side of the 10 feet. And you still have to get permission from the school on the bottom side, which is 10 feet, 8 feet, 12, whatever. Don't quote me. So, and then my question to him was, well, what about the other road, Walden Woods? That's a big road. And he said that's a private road. It's different. It doesn't count. And so I just felt like that point was being obscured, and I feel that is a central question. In my mind, that's central. And then obviously the A&R says practical, safe, and efficient. In Mass General Law 41, Section 81M, it says safe and convenient. Now, I'll leave the bitter pill question out of it, but I see the 10-foot bottlenecks as the issue and 81M.
Ms. McClarty.
Thank you. I'm alarmed by 2 things that John Eidman has stated to you all. Number one, that we cannot consider how the road came to be in this condition, the bitter pill. If the request was being made by a developer who had simply bulldozed woodlands to create a road and then come to you and say, I like an A&R, well, look, you have to consider the condition that's on the ground right now. That's preposterous, that you cannot consider that it was illegally achieved. To me, that's preposterous, because you would be required to make way for illegal actions. The other thing that is that we really wanted to share some of this research we did with you all, and we were instructed to go through John Eidman. I don't know if any of you were able to read these beforehand, but I noticed that when my husband quickly read some of this, it didn't seem like some members of the board fully comprehended. But basically, we as we have read it, being amateurs and simply concerned citizens, it does not seem to me that you need to simply determine whether this is a public road. This law that Sandy just mentioned, I'm not even good at reading these directives. Am I on it? I'm sorry. It does, okay, here it is. The public way, this is MGL 41, C41, 81M. Due regard for the provision of adequate access to all of the lots in a subdivision by ways that will be safe and convenient for travel. So this is the necessary conditions to be a public way, according to that. And then in this other case, where they talk about January Road, I really do think it would be a shame to make a determination if you don't familiarize yourself with that. The January Road having leaf litter on it, certainly Hall's Path had leaf litter on it before too, but the case is all about the fact that simply because it is a public way doesn't mean that it's adequate. And the case is all about that the condition of the road does have to be adequate. So if you don't have time to read that or didn't have time before, or if it wasn't brought to your attention because somebody didn't want you to read about that case, but read about another earlier case that was actually clarified in this one, that would be a shame to make the determination without all of that information. Thank you.
Thank you very much.
I just want to be clear, you're making presumptions about our town planner, and
Absolutely.
he is our professional. He knows what he's doing. He has advised us on all of the information that we need. And
How do you know?
And he made a very good point earlier that may have been lost on some non-attorneys in the room. The case law is fact-specific. So, with all due respect, your reading of a January Road case may be looked at very differently to many others of us in the room, because it is
Certainly.
very fact-specific. Every
Certainly.
case is different. Every street, every land, every property is different. So
I'm
you're
concerned.
You're making some allegations.
No, I'm alarmed. I'm alarmed that he is not impartial, and that's why.
Well,
Oh,
I
come
take offense to that on his behalf.
So do I.
He's our new planning director. He comes from the Cape Cod Commission. He's here being respectful to you when many others would not be. So I take offense to the comment on his behalf and on this board's behalf. You're
Well, so
making allegations that you don't know.
Since I'm an ignorant member of the public who's just emotional and concerned, perhaps you could take time to look at that case that I mentioned, just to,
You're suggesting that some of us haven't, and I don't think that's the case.
just based on the questions.
Thank you, Ms. McClarty.
There are many, I just have to follow up, there are many reasons why we ask questions in a meeting, and sometimes it's to inform the public, not because we don't know the answers to our own questions. So, please keep that in mind. We're trying to be respectful. The chairman has given everyone ample opportunity to speak. He hasn't cut anybody off in a situation where he didn't have to even allow public comment or public questions. So I just want to point that out.
And Mary, and two of us.
All right, thank you very much.
Chairman?
Yes, Craig, please.
Thank you. I kind of want to go back to what I asked before for the
Thank you.
clarification and trying to keep things as simplistic as possible. And with all due respect, Mr. Chairman, I'm not sure that I agree with the statement you made before that we need to take into consideration about making a decision tonight, based on the facts that were presented to us, because the Board of Selectmen is investigating how the trees got cut or didn't get cut, and all those other issues.
Right.
Which we talked about before, and I tried to ask the question and say, what is relevant to us? I'd be hesitant to make a decision based on something that may or may not happen in the future, and I'm not even sure what the outcome of that would be. So I wanted to say that
Okay.
with all due respect, sir.
Thank you. Well, I appreciate it. I think the matter that I had was that should we not endorse that was just the question is whether we do not endorse, what the signal that is internally to the town and to the selectmen. The selectmen have a presence here this evening. They're concerned with this. There's been ample public discussion about it. I just want to make sure that we hear all sides and we discuss, what our options are, whether we endorse it or we do not. It's a very simple thing. I mean, it's complicated, but it's a simple decision that we have to vote on. So, Mr.
Mr. Chairman, I for one would extend the courtesy that was asked by the school committee. I mean, it's up to the board, but I mean,
Well, that's what my question was. Do we have the luxury of that, being able to hear from the school committee, the school, time-wise?
That, again, it would, in order to not constructively endorse, that request would have to come, or that request and waiver would have to come from the applicant. If they're not willing to do that, I think you have to make your decision tonight.
Okay.
Can I add something to, I mean, I've really tried to, I'm new as your town planner, and what I'm always going to try to do is lay out the facts and law for you to try to make a good decision without imposing my own decision on you. I think I've done that. I've really tried to do that. I think I'm being impartial. And we haven't even discussed the alternatives yet.
Right.
So I've just laid out 1A is determining whether this is a public way. You don't see that, we need to discuss 1B, which is sufficient width, grades, and construction. But I also want to just say, the big picture here, this is an exception to the subdivision control law. If you don't endorse this, this means it's going through the subdivision control law. It's not a referendum on development in the town.
Right.
It's not a referendum on tree clearing. So you're limited in the subdivision control law to look at access. That's really what we're discussing this evening, and what we would discuss if this actually goes through subdivision process if you don't endorse it.
Mr. Chairman?
Mr. Singer,
Hold
yeah.
on if Mary wants to.
So my question is simply to just bring it back. If we determine that it's a public way, if this board believes that the information provided to us is sufficient for us to make a determination that we feel it's a public way, then we need to look at whether the road is safe and adequate under the law, and that's based on the conditions as they exist today, regardless of how they got there.
That's my opinion, and that the road has to provide, quote, vital access to the building portion of the site.
Thank you.
Right.
Yeah, and the term that's been used, it's really, could be better but manageable is the term that's been used in cases
Okay.
for public ways.
Thank you, John.
Mr. Singer?
Well, I'm going to take back what I was thinking of saying. I wonder, because we have these multiple levels and alternatives, if the board, and we've had a lot of discussion about, I think they've all kind of been lumped in together in many ways. I think it might be helpful if the board is willing to discuss the threshold question, because is it a public way? We believe it is, and depending on your response to that, may dictate how the rest of the night goes.
Right.
And so if that is appropriate, then I think that would be helpful to, and I know it's a decision probably none of you want to make, but it's the decision that's on the table, at least at the threshold level.
Right. And if we're talking about at the threshold level, we're talking about whether or not specifically this application meets the criteria of the language set forth in 81L, right?
Well, I just want to distinguish, and I'm listening to you now, not what Andrew said.
Okay,
because
sorry.
He characterized the threshold question as determining whether it's a public way.
Right.
I'm listening to you, and the determination to make is the determination of whether this is a subdivision within the meaning of Section 81L of Chapter 41 and Section 9 of Chapter 400 of the code.
Right.
Yeah.
So the reason I asked that is because we did look at the law, and I mean, I think we all looked at the germane copy that we had to get into, was provided to all of us, and it says in 81L, I believe it's, has to do with definition of subdivision and public way, Section C, or subdivision, or subparagraph C, talks about control, subdivision control law became effective in the city of town, with having, in the opinion of the planning board, sufficient width, suitable grades, and adequate construction to provide for the needs of vehicular traffic in relation to the proposed use of the land, right?
That's if something is not a public way or a way certified by the town or city clerk as used and maintained as a public way. So that's what I'm talking about, the alternatives.
Right.
If it's not a public way, you go to that section.
Okay. So how do we want to work with this? What is the pleasure of the board?
Mr. Chairman,
Greg?
is there, either to you or through you, is there a way to determine if the board decides that they would like to have it continued as requested by the attorney for the school? And if the applicant is willing to do so, is that something that we would ask now?
Help if we knew.
Right.
I think you could ask, I think you could take council's word for if they would grant the waiver, put it in minutes. I think they could follow up with some signed document tomorrow. It's something you could ask tonight. Another thing you might consider is, we've heard that this is a public way and it's not by layout, it's by prescription. You could always ask for more evidence about how has the public used this. So again, it's not just that people travel from one side to another. The argument is that the public in general uses it.
Right.
So you could always ask for that additional evidence. But again, you start with asking the applicant whether they would be willing to waive that time period and then continue to July 13th.
And so my question, Mr. Chairman, to John is, do we consider the section of Hall's Path where the school is that private? Because it's owned, both sides of the road is owned by the school?
You know, it's a tough one. I think one thing the applicant told you is there's a lot of, there's a land court confirmation case that calls it public, but the land court didn't really adjudicate it as being public. But there's at least one case I know of where there was a land court confirmation case, and the town is always a party to it, and the town was basically treated as acceding to the public nature of the road because they didn't oppose it in the confirmation case. So it's not.
So I think maybe the board ought to ask town council to give us more information on whether this is a private or partially private.
I've tried that
partially
myself.
public.
No attorney wants to dabble. This is the most difficult, thorniest area of law in the Commonwealth when you raise the question of road, street, or way.
Right, and that's only one part of that whole problem. And the second part is if they do not acquire more land to put the road in, then they will not have an adequate width or height to use to do a subdivision.
So I'll just ask the question. Mr. Singer,
Please.
will your client waive the 21-day period and let us continue to July 13th and give the Lighthouse Charter School the ability to come back and at least tell their half of their portion of the story?
I'm not going to immediately say no, but what I would like to say before I'm going to make a suggestion is that, with all due respect, I think the Lighthouse Charter School has given you their position. They submitted a 3-page letter saying that it's a private road, in their opinion. On a normal A&R, the neighbor has no neighbors have, it's not a matter of neighbor input. It's not a public hearing where the public testifies as part of a special permit where you're looking at the discretion of that. So respectfully, I think the school has given you their opinion. That being said, what I was hoping when I asked my question is that you were going to discuss the evidence that it is a public way so that I could then say what I'm about to say, but I'll say it first, which is it's been an hour and 40 minutes and maybe the chair wants to call a 10-minute recess and I can have some conversations and you can have some conversations if that is something you're willing to do.
That sounds reasonable to me.
Move that we take a 10-minute recess.
Second.
All in favor?
Aye.
Aye. Any opposed? Okay, let's do our recess.
Thank you.
Ready to go.
8:09. because of that.
All right, ladies and gentlemen, we've had our 10-minute break, and why don't we get back into session here? The time is about 20 after 8. Mr. Singer, have you had an opportunity to make your call?
Yes, Mr. Chairman. We appreciate your time. Also appreciate the request that you made. Respectfully, we do not want to grant a continuance of the time. We have been working closely with the town staff for, professionally, I might add, for the last couple months, trying to follow everything that has been requested of everyone who's involved on this side of the table. To the point that, to the way John classified it is, the threshold question is this a subdivision or not within the with A1L of Chapter 41 or 400, Section 9? That's what you're looking at. And we respectfully believe that we have submitted all of that evidence to you, whether it was a public way or as a private way. You've heard a lot of, you did graciously allow the public to speak tonight, and there's been a fair amount of character attacks that came from that. You've also heard from a select board member effectively arguing, that you shouldn't be acting on this. And with respect to everyone else who's looking at anything outside of this night, that all continues. Whatever is outside tonight will continue, good, bad, or indifferent. This is not a case where you can't approve it. Yes, there is more of the bottleneck heading down towards Route 137. However, as I stated, the road can be accessed all the way up to Pleasant Bay Road. Hall's Path can be accessed all the way up to Pleasant Bay Road, the way that this board has repeatedly analyzed A&R plans for many, many, many years. So we believe that as a public way or as a private way, that this road warrants and merits receiving an endorsement. And if you choose in your discretion to not so vote, then we would ask you, because you have to make a decision, which is based on all of the evidence you have in front of you, from the town, by the town, through the town, and everything we've submitted, why would you be finding it's a subdivision? Because that's what the question was made to you, and I believe it's a public way, but the answer, John, is correct. Under your rules and regulations and under 81L, it's either a subdivision or it isn't. And we respectfully don't believe it is. And if you disagree, which is your right to do, although we hope you don't, then you would have to please say why you think it is. And for that, while I realize it is probably not the answer you were hoping for, we appreciate your time tonight, but we would ask you to continue proceeding in your deliberations.
Great. Thank you very much. I see Mr. Howell has a comment to make.
Thank you, Mr. Chair. I had said I wanted to speak to a particular issue, but prior to that, I just want to make it very clear to Mr. Singer, I'm not here as a selectman. And I would not characterize it as that. The Board of Selectmen has taken a position that something egregious happened there, and they voted to have a subcommittee. This is not just my opinion as to the matter. Now, as to the sufficiency of the roadway, you've got a letter from the town clerk. It's a fairly old letter, but I had spoken with her, and she is not attesting to the fact that it was a townway that was traveled, nor is she attesting to the fact that it was of sufficient width and grade to be traveled. As a matter of fact, she point blank said, I am not an engineer, and I am not going to attest to that. I am just going to state what's in the bylaw, that it shows up as a public way. That's all she's saying. So don't read anything further in that, because you can't find it in that letter. There is nothing that makes that assertion, that it was well-traveled or that it's sufficient width and it was maintained. She has no knowledge of that, and she was not making that comment.
And just, thank you, Don, and just to respond to that, I wholeheartedly agree with what Don just said. I 100% agree with him. The letter says it's a town road, and that's what it says. Mrs. Smith, when she spoke, said that it was a public way, and she referenced Marty Moran's letter, and Marty was very well respected. He was a town engineer. I am not saying, and none of us are saying, that before recently the road didn't have issues, with and whether it was bottoming out issues. But look at your regulations. Look at 41. What Dawn just mentioned is not what I was, and again, we agree, I'm not saying that. The bylaw says it's a public way or a way shown on a plan therefore approved and endorsed in accordance with the subdivision control law, or a way which the town clerk certifies is maintained and used as a public way, or it predated 1949. I never said, and I'm not saying, for the record, that this road was certified as being maintained by the town. It hasn't been in this section. But, and I thought I referred to that, but please refer you to, again, it's either a public way or a way that predates 1949. That is what I'm referring to, and so I agree with what Don was saying.
Mr. Chairman, if this gentleman doesn't want to do it, we have every right to make a motion to continue this matter to,
But Joe, it's gonna get constructively passed.
Right.
It'll be,
Oh,
it'll
because
just
of
be,
the
it'll be because
time.
of the timeframe.
Because
It'll
of the
just be
time.
endorsed by the town clerk.
yeah.
Can
Even though it's a pending matter?
John?
I had one thing. I wouldn't twist yourself in knots about public way. The principal standard way to lay out a public way is through the layout and takings process. That hasn't been done. So just think of, I think Andrew has provided some good evidence for you to think about, but it certainly isn't the standard customary way. So I wouldn't get pulled into that and twist yourself into a pretzel. It should be pretty obvious to you whether it's a public way or not, with the principal way of making a public way being a layout. And understand the big picture here. If you find that this is a subdivision and don't endorse, it's not a referendum on development. You're not saying no development can occur out here. It means that the proposal needs to go through the full subdivision control law. So, I hope that big picture thinking helps. This is an
Appreciate it.
exception, what we're talking about tonight.
Right. Thank you. Ms. Toronto Flores?
Thank you. I just wanted to clarify one thing, if the board's going forward tonight, that was said about conditions on the ground today being, the focus of the board, and I think that's right. I just want to clarify one thing, though. To the extent that the clearing was done onto the school's property to that 22-foot width, that would not mean, and I don't think Mr. Singer is saying so, that they would be able to utilize that width, right? The school's property line goes to a width that's only 8 feet wide at that pinch point. And so in terms of this board reviewing the adequacy of the way, whether it's a public way or a private way, whichever standard you apply, just wanted to make clear that even though it is cleared to a greater width on the school's property should not be considered part of the width of that way. It's only 8 feet at that point.
Thank you very much.
Thank you.
And if I could also just respond to, I again, absolutely agree with what she said. The school's property is the school's property, and that is why I said that if that wasn't able to be worked out in the future between the two parties, then as within the past with approvals you've granted, there is the access clear and available access out to Pleasant Bay Road. So I do agree with what she said.
Thank you. Okay. I think we've got a
One
lot of
more
input
comment.
here. Please.
And I don't think we actually know if it is clear access out to Pleasant Bay Road, because we never even looked into that. We're assuming right now.
Right. Well, I think perhaps the existence of the gate testifies to that, but we need to take action here tonight, one way or another.
Why?
Well, because if we decide to let it go, it'll go ahead anyway, if we want
I
to.
understand.
So
It
I think we
automatically
ought
goes
to have, I think we ought to kind of
Automatically
have,
passes.
take a motion here and see where we stand, and
Mr. Chair, can I suggest one thing, the alternative? Let's pretend this isn't a public way. So let's pretend that this is a way that predated subdivision control, has the appropriate amount of lineal frontage, it's 150 feet. And the question would be, is this of sufficient width, grade, and construction to allow for vehicular travel and utilities for the proposed use, which is 4 lots. I'll add one thing from your own subdivision rules and regulations, which provide some real teeth. As specified under Table 1, which is the Table 1 of the road construction standards. That's why traditionally, and in Harwich, it's a much higher burden to meet if this is not a public way. So just think of that alternative as well. Because I think you have to go through both, well, you have to go through both exercises if you don't think that this is a public way. And you do, ultimately, I think it's better practice that you give a reason if you don't endorse this.
Right.
If you find that it is a subdivision and find that a subdivision approval is required, I think it is better practice to cite why you think this is a subdivision.
Right.
And I can help you with that as your discussions proceed.
So can I ask the question of my fellow members?
Yes.
Do my fellow members not believe that the prior endorsed, or do you believe that the prior endorsed A&R plans and the land court confirmation cases, do you feel that that's adequate evidence to say it's a public way? Because to John's point, it's not, it hasn't been laid out and taken.
I don't believe
But
it.
there are A&R plans that have been endorsed by the planning board, and there are land court confirmation cases that refer to it at least as a public way. And there's the letter from the town clerk we can even disregard because there's other evidence. Plus, there's a letter from Marty Moran.
Right.
I'll go, is this a question we're gonna
Like a
I'm
poll,
throwing
right.
it out there for discussion.
Okay. Mr. Chairman?
Please.
Respond. I believe it is a public way, town road.
Mr. Chairman, I believe it's not. I believe most of it is now because of the way it's been developed. It was private ways, then developed, then later on accepted by the town in different sections at different times.
Right.
And therefore,
Therefore, I don't believe we should do an A&R. I think it should be a subdivision request.
Because of the way, though,
All along,
that it
it's always
came
been,
about.
it's been piecemealed all the way through.
but again, to John's point before, that we need to take into consideration where we are today, not the sins of our forefathers going back to 1762.
That's true too. But
So,
it does not right now have adequate access.
so if I may, can we ask the town planner to walk us through the table under chapter 400?
That would be great.
Sure.
Because we have evidence that it was in existence prior to subdivision control, because it's on some
Should we
1800
continue
plans.
polling the board, though, to see where
Let's-
everybody's at?
Yes, let's get that prepared, John, but let's continue pulling the board. Arthur, do you have a position here?
I can't vote at this time
Okay.
on this matter.
Okay.
You can have an opinion. I mean, you
Have an
can
opinion.
participate in
Yeah.
the discussion.
I agree with Mr. Stoltz.
Okay,
But
thank you.
I reiterated the same thing. It was made after the modifications that they made to it,
Right.
so.
But that doesn't get to the, again, that doesn't get to the
No, I-
public-private issue. Yeah, I think your comments, Bill, maybe have more to do with this, let's accept that it's not public, and let's treat it as a non-public way that predated subdivision control. Is it of sufficient width, grades, and construction to allow for vehicular access and utilities? And I think what you're saying is, you don't think,
I don't
you
think it
you
does.
don't think it is, okay.
Joe, do you have,
I agree with Mr. Stoltz.
Dave?
As well.
How about you?
So that was the reason for my follow-up question, was if Mr. Eidman can walk us through the table.
Yeah.
I believe we have evidence that shows it was in existence prior to subdivision control.
We do.
So then it's walking through the table, as John pointed out, to see whether its current standards would, the way it's built now, would meet the standards under our table.
And everybody has seen this, by the way. We've all been out there and checked it out? Okay, good.
Yeah, it helps us define, the Harwich rules and regulations help us define what sufficient width, grades, and construction mean in the state act. So some certain road construction standards, and I'm using the category for ways, which is defined in the subdivision rules and regulations as a way which services 5 or fewer lots. So the layout, and there is no layout here, is a minimum of 40 feet. The minimum roadway width, which is the paved width, the traveled way, would have to be 20 feet. That doesn't exist here. And then there are kind of more technical analyses about horizontal and vertical alignment with the specific grades of the road. No engineer has ever really worked on the grades out there. There may be some rudimentary drainage, which is basically pitching and crowning, but there is not the type of drainage that the board would look for through a full subdivision plan. So I think you can probably assume that that road doesn't meet Table 1's requirements for the drainage you would require under the subdivision control law either.
Very good.
So, that being said, if it's, would you consider, if the board voted to deny endorsing the A&R, stating that subdivision, it needed to be, come under subdivision control, and the reasons therefore are because it does not meet the requirements of Table 1 under ways under Chapter 400-9.
Yeah, I think you would probably say it's a subdivision. It is a subdivision within the meaning of Chapter 41, 81L, and Chapter 400, Section 9 of the Harwich Rules and Regulations. It doesn't provide sufficient width grades in construction because it doesn't meet Table 1 of the Harwich Rules and Regulations for road design and construction standards.
Right.
Mr. Chairman, can I ask a point of order?
Just one moment. Does this ring true? Okay.
That's why I asked the
Yeah.
question.
All right.
Could I also ask, I mean, I understand what you just said, and that all presupposes that it's a private way to the comments that were made. Would you also, I would ask you if you'd be, please can address as well why you feel it's not a public way, based on all of the evidence that was submitted.
Very good. Thank you.
What I would suggest to you is that it simply has not been laid out as a public way, and there's been no judicial declaration of rights in the public in the way. I think that's what I would say is the easy response to that.
Excuse me.
Through you, Mr. Chair, to John. John, would you, the declarations, I would consider them findings? Yes or no? I mean, I guess the way I would think to phrase the motion is that the board moves not to endorse the A&R plan as presented based on the following reasons. One, there's not sufficient evidence.
Well, it shows a subdivision.
Right, it shows a subdivision, and the board believes it falls under the definition of a subdivision under Chapter 41, Section 81L, and Chapter 400, Section 9 of the Harwich Code, that the road does not provide a sufficient width, grade, and construction for safe and adequate travel?
You could say safe and adequate, and, as specified under Table 1 to
Safe
said
and
Chapter
adequate
400.
Travel under Table 1 of Chapter 400. And further, the evidence has not been presented that the road in question has been laid out under the provisions of Mass General Law, and that no judicial declaration of rights to the general public have been declared.
I think
Second.
that's very good.
Is that sufficient?
Yeah.
Thank you.
We have a motion. We have a second. Do we have any further discussion?
Yes, please, Mr. Chair.
Sir,
What are we voting on now?
to deny,
Voting not to endorse the A&R, that is the motion.
deny the endorsement.
Thank you.
Any further questions? Suggest we take a vote. All in favor of the motion? Aye. All opposed?
No.
So we have it.
That's it. Yeah, just simple majority
Simple majority.
for subdivision matters.
Thank you, Mr. Singer.
We appreciate your time. Thank
Yeah,
you.
appreciate your time. Appreciate the public's participation in this as well. Thank you very much for coming out.
Mr. Chair, how this works is we actually will file this motion with the town clerk.
Right.
Because there is no endorsed plan to file.
Right, okay.
So I will work on this tomorrow and file it with the town clerk. And we also provide notice to the applicant that we've so filed with the town clerk.
Okay,
And give
thank
them a
you.
copy of that.
I have a few days on the road. Can I come in on Thursday? Is this something to be signed this week, or?
We'll see. I mean, I could talk to you and
Okay,
sign
all
on
right.
that.
We'll go offline with that. Okay, very good.
Mr. Chairman,
Yes, sir.
when will that have to be signed?
Well, it's even, you know what I've seen in the past, more in the nature of a memorandum.
Right,
From the
okay.
planning board rather than a signature. It's letting the town clerk know
Right.
that you didn't endorse it.
Very good. Just a notification.
Because after Friday, I won't be available for a week or two.
Yeah, the board doesn't even, as the board, you don't need to sign
Okay,
anything.
all right, all
Because you're not endorsing anything.
Okay,
I don't even think I'm gonna be able to sign anything.
You don't need our signatures?
no.
It's essentially notice so that she doesn't constructively endorse it when the attorney comes in and says the 21 days have passed.
Precisely.
Not that Mr. Singer can have it. That's what it is.
Okay, so we have a second item in our public meeting this evening. I'd like to go to item 2 in new business, PB 2021-13, Harwich Affordable Housing Trust as applicant. Thomas Stello, PLS representative, seeks endorsement of an approval not required plan for 3 lots set forth in MGL Chapter 41, Section 81P. Parcels are identified as Assessor's Parcel IDs 82-R2, -R1 and -R3 at the 283 Pleasant Lake Avenue and 0 Pleasant Lake Avenue respectively. The parcels are located in the R-R and 6 Pond zoning districts. The plan is entitled Plan of Land Pleasant Lake Avenue, Harwich, Mass., prepared for Harwich Affordable Trust, prepared by Thomas M. Stello, PLS, dated June 10th, 2021. Mr. Stello.
Tom Stello from TS Land Surveying, here to represent the Harwich Affordable Housing Trust Fund. As it states on the plan, the purpose of the plan is for a boundary agreement adjustment due to a deed description inconsistencies, and also there's a lot of encroachments. Basically, what you have is a deed that was created back in 1918, which is shown as a dashed line, and it's presumed that that was a mistake and that there was actually supposed to be a distance of 264 feet. Since there was such a great discrepancy, the attorneys instructed to have this filed as an A&R plan and seek endorsement, where typically that would not be the case. If you have any questions, I'll be happy to answer them, but that's pretty much it for this project.
All right, why don't we hear from the town planner, please?
You know how I said on the last matter that.
Here we go.
Yeah.
This is a simple one, right?
This is one of those, I would say, simple and perfunctory ones. For the primary reason that that very interesting thing called Bassett's Lane on the plan was one of those type of ways laid out prior to 1850.
Right.
Very interesting historically. And it's not just a paper way.
Right.
There actually is, it's not a.
You can walk it.
It's not a super highway, but you can travel it.
Right.
I
And
drove
you
my
can
truck
bring
down
your
as
You
it
could,
is.
you could drive it, yeah.
Does travel mean by vehicle or by foot?
I did by vehicle. I've done it many times. I did it today, earlier today, a few
Yeah.
times.
Fair-wheel drive with 18-inch
both.
lifters or?
Just don't access it off Pleasant Lake Ave. You can't go that way.
So there's actually a layout, and, my research is at that time, and I don't know what the magical number was, but for some reason they were laying out roads to 22 feet. I don't know what the magic was. There were no vehicles, but it was 22 feet. Two horses passing in the night.
Right.
An extra foot on
Model
either
A's are
side.
6 feet
Yeah.
wide.
Yeah. So this is, I will not always be so presumptuous, but here I really do see, given the cases, this is a town way.
Right.
The road is not illusory. The cases suggest in that case, it really warrants endorsement.
Right. Do we have any questions?
I do. There's 3 lots.
That is correct. And one of them is not a buildable lot.
That's the one on the state highway.
Yeah, the little triangle one.
That's on the far left there with the cut-off apex on the left?
Yep.
Obtuse, okay, great.
So that's not gonna be built on?
It is not, no. It can't be built on per zoning bylaws.
Well, to be clear, it's not separately buildable.
Okay.
It's not a separately buildable lot.
Okay.
I don't know what will happen in the future, but it's not a separately buildable lot because there is no frontage on that Bassett's Lane.
Right.
And there's less than the required frontage on Pleasant Lake Avenue.
And there's a note right there as well, right? Describes that, it states
Right, I saw that. So you're saying you could possibly subdivide that later?
it could be
And try to get that
combined
lot.
with another lot.
Right.
That's about all you could do.
And this third lot, the large lot, is partially in Zone A of the 6 ponds?
Correct.
Zone B.
That's correct.
And, okay. Is this a multi-family zoning area?
Well, in Harwich now, almost every district, but 2 of them are multifamily districts in that you can do it by special permit.
Okay.
In nearly every district, but, what is it, CH1 and the industrial district.
But it's not
No,
an
CH2,
Yeah.
up in East Harwich, that's CH1 or CH2.
It's not an MR1 or MR?
No, it is not one of those multi-family districts, MR1 or MR2, yeah.
We have our liaison to the, no, we have a citizen?
No.
No?
No, we have the chair of the Housing Trust.
Jerry? Okay, excuse me. You need to get like 3 hats in here, Don, please.
Plaques behind me.
Yes.
I think it would be reasonable to infer from the, who's buying it that we will not be developing this under 40A. And in terms of what it is, we have absolutely no preconceptions. That's a whole separate public process that we need to go through later on. This is about perfecting lot lines that were messed up on the ground compared to what they were written on paper. And I might point out to you that one of the things that we're doing is moving a lot line to the disadvantage of us as the purchaser for Mr. Marceline's son, because my belief was the aggregate acreage that we had bid on was satisfied with the lot line where we thought it was. It turned out during a physical inspection of it that Tom ran across the fact that it surveyed out so that we actually could have claimed more property as part of this transaction. We have decided that that's a fight that's not worth having, and that's why we're here, just to get this signed off on so that he can keep the property and we can move forward with whatever the future holds.
Also should be added that the assessor maps do show it the way that we're proposing it. So it's
Okay.
always been presumed, I'm guessing it was presumed to be a deed error in there, and it just was never corrected, and the discrepancy was just so great.
Right.
This was the best way to fix it,
Okay, great.
and the right thing to do.
I'd like to just make a motion.
Please.
So I move that the plan entitled Plan of Land, Pleasant Lake Avenue, Harwich, Mass., prepared for the Harwich Affordable Housing Trust Fund by TS Land Surveying, Inc., Harwich, Port, Mass. 02646, dated June 17th, 2021, stamped June 21st, 2021, does not depict a subdivision, and move that the planning board endorse the plan as not requiring approval under the subdivision control law.
Second.
We have a motion, we have a second. Any further discussion? Let's take a vote. All in favor, say aye.
Aye.
Aye. Any against? It's unanimous, I so declare it. Very good.
Thank you very much.
Thank you, sir.
Nice to see you, Tom. It's been a while. John, that's
You know
why
why
you get
that
paid the big
is?
bucks.
Right.
Well, you got an education.
Because you got it in at the last minute.
Thank you for your patience. So we have minutes for their May 25th meeting.
I move that we approve the minutes for the May 25th, 2021 Planning Board meeting.
Second.
All in favor?
Aye.
All opposed? It's unanimous. We have advisory opinions from the Zoning Board of Appeals. I believe that we all know how to read. I'm not going to go through those.
Mr. Chair, may I add just one point of
Please,
interest?
sorry.
So I always I just want to keep an eye on things that may come into the planning board's
Okay.
jurisdiction or concern. So I won't look at, notwithstanding Mr. McParland, I won't look at single-family homes even if they're in the campground. But there is one, there is
Don't
one.
you already, Joe?
There is one commercial project. It's a variance for that ATM near the Chuck Wagon Corner. Okay.
Oh, yeah.
And there's an interesting general law, Chapter 167B, Section 3, that requires banking institutions with electronic, ATMs to come up with safety plans. And so they're generated by the particular bank. Bank of America filed one. It requires certain minimum light levels. Those minimum light levels are not consistent with our dark sky bylaw. So they essentially have to apply for a variance to satisfy the state law and their own guidelines in terms of safe lighting. So, I mean, I wasn't thinking about making a specific, comment to the Zoning Board of Appeals, but I also don't think there's a basis to, say, object to the variance.
Right. I also would like to thank you for saying Chuck Wagon Corner, a phrase I have not heard since like Jimmy Carter was president. I was like, love it.
Since 1846.
Yeah, since 1846. That's fantastic.
Since Kennedy was president.
Yeah.
Mr. Chairman?
Yes.
John, I have a question.
Sure.
If I heard correctly, you said that the bank's security rules about lighting and the state of Massachusetts rules are different than the town of Harwich's dark lighting? So does that mean the town of Harwich is not in compliance with the state of Massachusetts?
No, because we don't have, under the statute, we don't have to comply with that. Banking institutions have to.
Okay. Thank you.
They look right. My friend lives on 21st Street. You looked up there,
I'm sorry to tell you, they haven't been installed yet, what they're seeking the variance for.
the ones that are there already in the park.
Well, that's what I'm saying.
You can
I'm
see
not
it,
sure it's going to be,
you can see it from the International Space Station, live, right? It's like-
But all due respect to all of the rest of you in the room, some of us, when we get out to use an ATM, appreciate the bright lights.
That's true.
I'm glad I don't live next door.
Yeah,
But
yeah.
I looked at the photometric plan too, so it's like 3 at the lot lines, which is not like out of control. 3-foot candles at the property lines. Yeah.
All right, we have old business language revisions for the 2021 Planning Board schedule to accommodate general planning discussions.
This is just a simple thing I tried to simplify.
Okay.
I was worried with the schedule. First of all, I want to put back on there that we're in person. But I also wanted to, there was some confusion I felt with, it said things like waivers of site plan and A&Rs don't need to meet that's not the case. Because with waivers of site plans, you actually need to notice 10 days prior, not file 10 days prior. Because even though it's a waiver, the unique provisions of our bylaw require us to notice. So I could see how somebody would rely on the schedule. Nobody should ever rely on the schedule. They should rely on the time frame set out in the general laws and our bylaws. We do our best to meet the schedule, but we are not obligated to do so. We're obligated to meet the time frames in the law, general laws in our. So that was some of the thinking behind redoing this. I also tried to use what's called an accessible font.
Yep.
It's easier for people with, visual and other challenges to see online. So I used New Times Roman, which is considered an accessible font.
I think some of those deadlines were really more staff deadlines for publication in a newspaper, more
Right.
than anything else.
Yeah.
A point well taken.
Do we have
We
any,
need to adopt it? We don't need to adopt this.
I don't think you have to.
No.
Looks good.
Yeah, but I'm always going to share.
So that's
You know,
the
I'm
new
still
one,
new to you. I'm just going to share everything.
That's a new one.
Put a line through draft.
What's that?
Put a line through draft.
Oh, yes, I'll take the draft off, yeah. I won't put the line through it, because that would even be more awkward.
all right, and we have briefings. Any briefings from any other, Craig?
Mr. Chairman, not a briefing, but a request or proposal or suggestion to the rest of the board members. I'd like to see if we would be willing to do the Pledge of Allegiance, salute the flag, Pledge of Allegiance at the beginning of every meeting.
Couldn't agree with you more.
No objections.
I agree with that.
If I need to
Terrific,
make it a
let's do it.
motion, I will, but
Well, why don't we just, can we just do it as a standard
do it.
practice? And let's make sure that we All right, and if I fail to do that because I'm in a trance, can you like give me a zap?
The Marine
Right,
Marine will.
right, good.
He's good at it,
Do you mind if I put it in the agenda?
please.
Love it,
Okay,
even
the
better.
select board does that.
That's no guarantee that my trance will get,
We may get
Broken.
some grief from it, but we'll do it.
We're not gonna make you
from
sing the
us.
Marine Corps hymn, for Christ's sake.
No.
From the hall.
Bill, did you have something you wanted to mention too?
Some new business?
Okay, please.
John and I were talking, and there is a zoning law in Brewster that you called, I think he called the dirt road.
It's colloquially called the dirt road bylaw, yeah.
Right. And it's something that we should probably listen to, because we'll involve all these small cart paths, and footpaths, and et cetera, that tie into other roads. And it seemed to be a fairly nice way that Brewster eliminated a lot of that.
By adopting this,
Dirt road
This
bylaw.
dirt road bylaw.
And is it a clarification process, or is it a
did,
checklist
right,
kind of a
John?
thing, or?
No, I'll explain it a little bit. My conversation with Bill, as well as, the board has, I think, significantly more discretion with A&R plans than has been exercised in the past. Even and we've seen tonight with this, basically, if you don't have a public way, you're meeting the subdivision rules we have. I mean, that's almost intended to, well, you're going to the subdivision, you're going the subdivision route now. Brewster has rules very similar to Harwich in that way, and has always enforced them as such. When Brewster changed its laws in 1972, there were a lot of allegations of takings and variance asked to build on lots that were then made undevelopable or unbuildable because of the changes in the bylaws. So the relief valve Brewster created was something called the dirt road bylaw, where even if something wasn't considered a road, street, or way as so defined, with frontage as so defined, it could just be a cart path. But so long as you have 5 acres, you can put a single house there. So it was kind of a relief valve of all the takings claims.
Right.
And the request for variances, because the board in Brewster, the zoning board, after that law change, they were just granting, they felt bad, and they were granting variance after variance with little statutory reason to do so. So this seemed to be so my bigger conversation with Bill was perhaps looking at, the subdivision rules and regulations we have, even subdivisions. Having a bigger conversation about, what do we want the subdivision rules and regulations to look at as well?
Right.
There's some difficult portions of our rules and regulations, like there's this whole concept of a safe and adequate access determination lumped in to the A&R provisions in this 400 Section 9. I think it's a fair section to have. It should be in the zoning bylaw. The thing that's so strange about it, and Harwich is the only town that I know that has it, that you essentially can use the section to make roads that don't meet the regulations by clearing, and it's a little bit strange. So even with the plan we saw earlier, the one way they may have gone amiss is they probably, under the 400 Section 9, should have come to the planning board first. And you've seen this for safe and adequate access determination,
Right.
saying we want to do X, Y, Z.
Right.
But I'm not even sure that's the best thing to have in the rules and regulations any longer. You probably want to default to subdivision.
Well, you saw the uncertainty in the public here.
Yes.
And this is part of I think the issue is that when you open something up like that, then people fill it in with motives.
Yeah.
And I think that's kind of like what we saw tonight, is there's a kind of lack of trust. I mean, some of it's justifiable, some of it's not, but I mean, this is the reality that we're dealing with, and unless we can clarify these things, people have every reason to be suspicious, I think. I mean, it means a reasonable posture to take.
I'd say for myself, I would welcome any recommendations you have to changing our regulations and our tables and all of the rest of it.
Okay.
I think we've tried from time to time to do some things when we can, but
We haven't looked at them for a very long
we
time.
haven't
Right.
looked at those, and certainly in a while. We've looked at some of the zoning, but in specific areas. But any recommendations would be greatly appreciated
Okay.
by me, so.
I think there's some really interesting things we might be able to do with the subdivision regulations themselves as well. One example, we have minimum paved width.
Right.
You know,
Yeah,
the
we were
maximum.
talking about this, right?
Yeah. How about the ability to perhaps, you know, there are certain, the problem with the subdivision law, at least the way Harwich has it, is once you're in subdivision, you have to create highways.
Right.
There may be areas you want to keep the quaint character of certain parts of town and know that you can do that,
Have
given
more
the number of lots
variety.
proposed.
Right.
Yeah, with something that's less than a 24-foot paved way.
Right.
So, you know, even minor tweaks like changing minimum and defaulting to perhaps, you know, that the planning board, rather than just relying on waivers requested by applicants, maybe, you know, do a little legal research, determine whether the planning board can put in a figure and then require a reduction. You know, either that something isn't paved or require, you know, 20 foot of paving, but in certain cases can require that be reduced down to, say, a minimum of 16.
So personally, I'd love to get behind any of those things. So I think this is exactly the kind of conundrum that we face now, is that the one-size-fits-all language in a town where there's, again, so many nooks and crannies. We got to respect
Yeah,
the topography. So
yeah.
You need a signature on a document.
You voted not to endorse, so please don't.
Okay.
all right. Do we have any other business before the board here?
I just have a broad general question, I think. How do we ensure that the information that we're being presented and asked to make decisions on, I know that each one of us can decide how much credence we put into it or not, but things more of a technical nature, what I'm thinking of, like somebody regardless of the meeting tonight, but I use that as an example because it's fresh, the choke point is 8 feet. How do we know,
Right.
and that's from a public citizen, he may be right on to the millimeter, or he may be off by a foot, but it's stated, nobody questions it, we don't have the town engineer here to verify it or link for DPW or anything like that. Similar with the letter that someone asked the fire chief to submit, which explained how they approach that particular road now, or calls on that road. But when was that discussed, and did the chief go out and see it as it exists today, on which we're supposed to be making our decisions? Or was that saying, well, that's the way we always did it? He may or may not know that improvements or not
None of
may have
them-
been made. So
None
how
of
do
them
we-
wrote those opinions relative, I was really troubled by that.
Yeah.
Because none of them wrote those opinions with respect to this application. It was a general ask.
Correct.
I think you have to question everything. This is all just evidence, and I think you said it perfectly. Evidence you have to give the speaker and the information the amount of credibility and, you know, deference you think it deserves.
Right.
And if I can say, that's also why we rely on John.
Right.
You know,
Correct.
he's
But
a
like, I mean-
professional, he's a professional in the room, not the rest of us.
Absolutely,
So-
and I would agree with that, and.
Which is why I
and
took
do-
such
and do.
offense.
And I agree with that too, and I'm
So-
glad that you did. But John wouldn't know the example I just gave about the fire chief, right? I mean, so that would be something, if we wanted to get to the fact, because as you said, it didn't, you know, reference this hearing tonight or anything like that. It was just, this is the way we used to do it, or this is the way we do it now. But if these improvements, quote unquote, have been made, maybe they wouldn't do it. And did the chief go out there and look at it before he answered the town person who asked the question? I don't know.
You would you would do the same thing you're doing now, and then you would question perhaps the materiality of that piece of information.
And you could ask for the town engineer to go check it out
Yeah.
and survey it.
But that's
Except-
also why, when I asked the question whether anybody, the police or fire had commented, John pointed out that we typically don't do that on an A&R, on a standard A&R. We do it
Right.
on a subdivision,
Right.
which makes complete sense, which also leads you to question what was said. If they're not typically commenting on an A&R, what was
How
the
do they
basis,
know?
what was the basis of the ask? And I think everybody's just trying to make the best case
Right.
in their own opinion,
Each side of it
and I
is,
appreciate
of course,
that.
trying to do their thing.
But that's why
Joe.
we have to make decisions.
I also think that we should think about, we did do it in the past. We can request the police chief or the fire chief
Right.
Yes.
to please appear, and they've always, never been a question, and then they've always been glad to come in. And so I think if the, and I would assume the chair
Yep.
would handle that. If the chair thinks that there's something on the agenda that we need the fire chief here for, or the police chief here for, pick up the phone and call them, or have John.
Well,
take
two
that.
things struck me about tonight. First of all, or three things. First of all, it's great that we're all back and doing this together. This is, could you imagine trying to do
No
this
way.
thing with
It
Zoom?
would never
This is
happen.
probably the most complicated meeting that I've chaired on this board, and I would have to say that I had so much traffic, communication traffic of aggrieved people one way on both sides of this issue. So I thought that at least, I'm sorry that it got kind of a little bit out of hand here in terms of the general courtesy, but that's, I think, the risk that we always face. I mean,
I'm a big boy.
you're a big boy, and guess what? I've seen it get a lot worse. And
Yeah, I
let's
have
hope,
too.
and I don't want that to get, we won't let that ever happen, and that the worst thing. But flip side is, I think there's a lot of pent-up energy from COVID, and a lot of this stuff is getting vented because of the fact that we can meet in person. So it's just a peculiar thing that we have diametrically opposed assertions of fact and diametrically opposed interpretations of statute. It seemed to me that we were dealing with like a hologram tonight, and I thought, we did a pretty good job.
In my own opinion, that's why we rely on our
Right,
advisors and not
exactly.
everybody else's.
Exactly, but I thought we ended up kind of coming through okay here, so.
You did.
The other thing that's nice to see too is that young people are taking an interest
Yeah.
in the town
Right, yeah.
policies
Yeah.
Yeah.
and wanting what the
What's
board
best
is
for the
is
town.
looking to do and make sure
Yeah.
that everybody in the town
Yeah.
is listened to and heard and,
Right.
make an opinion.
I agree with
I think
you.
it's really good to see that.
Yeah.
And you have to
Yep.
look at, for the last year and a half, people have been cooped up, they've been misled, they've been, all kinds of things going on. So if this younger generation is questioning everything being done, then more power to them.
Amen.
Absolutely. People want to get back in the buildings too. Like-
On this one, I would like to have seen the physical conditions and the way things happened in the last day and a half. Or, I picked up my packet on Monday, midday, and I would have liked to have driven out there and seen these conditions.
I did.
Yeah, I did.
I did.
The law makes it
Pretty have a
very,
chance.
law makes it very difficult. So we just received this that's what happens with A&Rs. Actually, if someone can submit an A&R in, with a 48 hours prior to the open meeting, and you could theoretically get on a meeting. You don't have to notice it, you don't have to publish it. So
And the
It's
21
really
days
tough.
starts ticking.
Right.
upon submission.
I went out this afternoon at 1 o'clock and I found 2 stakes that somebody had put in, had ribbons on. One said road layout, one said property line.
That's
I
the
don't know
most
who did it.
disturbing part to me, is
Yeah.
that somebody moved boundaries.
Yeah,
Right.
And of course,
Monuments.
There
That's-
isn't a contractor around that doesn't know they're not supposed to touch
Right.
boundaries.
exactly.
And that's
They
a
know they're
criminal
not
act
supposed to
under
touch
the MGL, so that has nothing,
Right.
you have no jurisdiction
Right.
over
Right.
that, but somebody does.
Right. And I think that's part of the pressure that we saw this evening, was there was an outrage about that, and it was ginned up online, it was ginned up, at the selectmen's meeting, so it's natural it's gonna spill over
But
here.
somebody else is gonna make that decision.
Right, right. All right, folks, we're after 9.
Second.
All in favor?
Aye.
Thank you.